So, Mr. Garza, we're talking about a case that has made headlines over the weekend. We're talking about Mr. Morson's case. We saw his bond dramatically decreased.
Right.
I think the question on everyone's minds right now is, why wasn't your office able to meet that 90-day deadline to bring his case in front of a grand jury?
Right. What happened in this case is approximately a month before the deadline, we recognized some significant management problems with a 20-year prosecutor who was handling that case. We immediately took action to demote that prosecutor, and she subsequently resigned without notice. We put another prosecutor on the case who has been fabulous. At the time, that prosecutor was coming back off of parental leave, and as soon as she got back to the office, she got straight to work, reached out to the family, prepared to present this case to a grand jury, did a fabulous job, and had this case indicted on the 91st day. But I want to be clear about something. Under the law, the court had authority, once the case was indicted, to ensure that bail was sufficient in this case to protect our public safety. The Court of Appeals has been clear that once the case is indicted, regardless of when that is, courts have the discretion to take action to protect our public safety. At the time of the original bond hearing, the case had already been indicted. Our office argued that this defendant posed a threat to public safety, and that is why we re-urged the motion again today.
Judge Elridge this morning had said essentially with the initial bond reduction, her hands were tied. She said that she had to do this because of the missed deadline in your office. What's your reaction to that?
Yeah, that is both factually and legally untrue. I have shared with you a case that is from 2015 that is directly on point. That is to say, it answers this question directly. In that case, a person was not indicted within the 90 days, their bail was reduced, and subsequently the district attorney's office filed an indictment, and the court held, of course you have authority once the indictment is brought to consider public safety and to make sure the bond is appropriate. In this case, at the time of the original hearing, the case had already been indicted. I will also note that the legislature has weighed in to this question just today. They have affirmed that that is in fact the law, that courts have the tools right now to keep our community safe once a case is indicted, and that they should use them. And so that's just not a correct statement of the facts or the law in this case.
Nonetheless, it was a missed deadline that happened in your office. You had said that the situation has already been rectified, but I think for a lot of people it's frustrating that this sort of mismanagement was happening under your roof. How do you feel about that? What's your reaction?
Well, let me say a couple of things. First of all, every year there are cases that the district attorney's office does not indict in 90 days, and there are lots of reasons why. We've done a review of cases in our office over the last year, over the last 14 months. The overwhelming majority of cases not indicted within 90 days are not indicted within 90 days either because the person is receiving mental health services or because we don't have sufficient evidence to proceed to have the case indicted, and we're working with law enforcement to get the evidence that we need. It is obviously our goal to make sure that every case is indicted in 90 days, but it is just a fact that cases are not always indicted in 90 days. We take this very seriously. We are reviewing it carefully to make sure that this doesn't happen again, but I also want to be clear that courts do have the authority, once the case is indicted, to ensure that a suspect stays in custody. That was the fact in this case. That's what we hoped the court would do originally, and we're glad that the court did it eventually.
Why do you think that didn't happen the first time around?
Well, I think you just reported on the judge's statement about the law. It sounds to me like the judge misunderstood the law.
We spoke to the victim's family in the Morson case, who is placing the blame on you, saying that her family was living in fear, knowing that this violent offender was back out on the street with posting bond that was drastically reduced.
Right.
How do you feel about that sentiment?
Well, my heart really breaks for the victims in this case, and I am terribly sorry for everything that they have been through. They deserve solutions, not finger pointing right now. What is important to me is that we are doing everything we can to keep them and our community safe. I'm really proud of the job that our prosecutor did. Once she got on the case, she did an exceptional job. She has been fighting for this family. She and the rest of our office are going to continue to fight for justice in this case.
Mm-hmm. Do you feel like there needs to be an audit of the people who are working under your office right now, given this slip, this situation that caused us to miss this deadline?
As I said, we've reviewed these cases over the last 14 months. We are taking a very close look at this to make sure that everyone has what they need to make sure that we're meeting these deadlines. But I do want to just point this out because it's important for us to be accurate here. Mm-hmm. There is no deadline for prosecutors to indict a case. The only deadline we have is the statute of limitations. Mm-hmm. That is the law that says if you've passed a certain point, you can no longer prosecute. So long as we're within that deadline, the district attorney's office can indict a case whenever it has sufficient evidence to do so. And again, the law is clear that once a case is indicted, courts have the authority to make sure that the bond is appropriate to ensure the safety of our community.
Yeah. Just a little while ago, you were mentioning how this actually has happened before.
Sure.
Can you talk to me a little bit about the role that APD plays? Is that a delay as well, getting the evidence from their department into your office?
So we're working closely with APD, and we have been for the last several months, to make sure that the process of getting evidence from detectives and officers to our office is happening smoothly and quickly. What I will say is I think both APD and the district attorney's office are dealing with technological and cultural challenges in the Travis County court system about how evidence moves. But I am confident that Chief Davis is committed to this. APD has already taken action to make sure that evidence is getting to our office quickly. We both still have work to do, but I feel confident that APD leadership and their entire team is treating this with the appropriate level of seriousness, and that we are working to make sure that this system works as it should.
Outside of Morson's case, though, do you feel as though APD could be quicker on getting you that evidence into your office so we can secure an indictment?
Well, as a prosecutors, we want all the evidence as quickly as we can get it in every case. Obviously, the district attorney's office prosecutes felony cases. These are all very serious cases. That being said, we understand that in some situations, APD has challenges that they have to work through. What is important and what I am grateful for is that we have identified these challenges. Our communication is really good about what steps we need to take to resolve them, and we're working to resolve them.
Right now, I'm sure you can understand that a lot of the blame of this specific situation and case is being placed on your office. Do you feel as though you have to take the responsibility for all of that blame?
Well, again, I think what our community deserves is solutions, not finger pointing. It is my job to be accountable to this community, to be honest and to tell the truth about what the law is and what the facts are. I will let our community decide who's at fault or who should be blamed. What my job is to make sure that we have solutions in place and that people who pose a danger to our community are being held in custody.
One of my last questions for you is, obviously it's a major concern for someone who's considered to be a violent offender to be let out on a drastically reduced bond back on the streets of Austin. Do you feel as though this could have been avoided? Could this have been prevented in any way at all?
Absolutely. It absolutely could have been avoided. Again, the law says that once a case is indicted, courts have the discretion to consider the safety of the public. During the original hearing, the case was indicted, and our prosecutor in that case argued that this defendant posed a danger to the community. We did not get the result that we wanted in that hearing, but we have a responsibility to continue to do what is in the best interest of our public safety. So we filed another motion, had a subsequent hearing today, and today the court made the right decision, and we're grateful for that.
How often would you say that the 90-day threshold is not met? And what kind of danger does this pose for people who are worried that these violent offenders are let back out onto the street?
Yeah, that's a great question. So we reviewed cases from the last 14 months, and just to give you some perspective, in 2024, our office received 18,000 felony cases. Of our review, we identified approximately 250 cases. I have to go back and check the precise amount, but around 250 cases where the defendant was not indicted in 90 days and was eventually released. Now, it doesn't give us a lot of information about why they were released, but here's what I want you to know. We have gone back and reviewed all of those cases, and what we have found is in the overwhelming majority, not indicting that case was the appropriate choice. Again, the majority of those cases are instances where a suspect has significant unmet mental health needs and is receiving mental health treatment, and we are waiting for the suspect to receive that mental health treatment before we move forward with prosecution. The second biggest category is just cases where we had insufficient evidence to move forward. There are a range of things that we do in those cases. Sometimes we dismiss the case and then re-indict it once the evidence is in. Sometimes we simply make the decision not to indict because we don't have the evidence. So we have reviewed, as I said, those cases from the last 14 months. The overwhelming majority are for the reasons I've stated and were absolutely appropriate. This is something we take very seriously.
My last question for you is, what would you say to people right now who are saying that you are allowing violent offenders to be let out into the streets because of a lack of organization or management in your office?
Again, I would just reiterate that the law is clear, that once a case is indicted, that is the job of the district attorney's office, is to indict cases that we intend to prosecute and for which there is probable cause. In this case, the case was indicted on the 91st day and was indicted by the time that the hearing was held. The legislature did not create a get out of jail free card for people because of administrative or technical errors. That is not the law. The courts have been clear about that. The legislature was clear about that today. Courts have the tools that they need to keep our community safe. We just need them to use them.
Mr. Garza, anything else that you want to add that maybe I haven't yet asked you but you think is important to note?
No, I don't think so. I think we've covered most of it.
Thank you so much. Thank you for your time. I appreciate it. And thank you for this. This is incredibly helpful.
You bet. Thank you so much.